Good morning, everyone. I'd like to hereby call to order the rezoning hearing, Planning Board rezoning hearing for August 3rd, 2021. We do have 1, 2, 3, 4, 5, 6, and one on the phone, 7 members, so we do have a quorum. Before we go further into the meeting, we do have one of our Planning Board members that is joining us via video conference today due to the fact that he's had some exposure to the COVID pandemic, and so I've been advised by our legal team that he can participate if the board sees fit. We just have to make a motion to bring it in, and this is considered extraordinary circumstances. That's why it's allowed. Normally he would need to be here in person, but because of the extraordinary situation, he can participate. So at this time, Chair will entertain a motion to allow Mr. Tim Pyle to participate via video conference.
So moved.
Motion?
Second.
Second. Any discussion? All those in favor say aye. Aye. All right, that passes. At this time, I'll ask everyone to please turn off your ringers and noise makers as to not interrupt the meeting, and we'll ask you to please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, good morning, everyone. Before we go into our agenda items and going through our required quasi-judicial statements, I just want to kind of let everyone know, because I see we have quite a few participants today. Typically, we go into our rezoning hearings first. That's our first agenda item, and we do those in quasi-judicial, which basically means it's recorded by a court reporter and everyone's under oath. In today's situation, we will open that meeting and then put it on pause to go into the regular planning board meeting to handle the small scale amendment. That's the way we have to do it, because if that amendment doesn't pass, then the subsequent rezoning can't stand on the shoulders of it, so to speak. So a little procedurally different today, but that's why we're doing it that way. With that, staff members, do we have proof of publication of the meeting?
Yes, sir.
Okay. Does that publication meet all of the legal requirements?
Yes, sir.
Okay. Chair will entertain a motion to waive the reading of the legal. So moved. Motion, do we have a second?
Second.
All those in favor say aye. Aye. Opposed? All right, motion carries. Board members, you've been previously provided the rezoning meeting minutes from the previous meeting. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
So moved.
Motion.
Second.
Second. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. The rezoning hearing package for August 3rd with the findings of facts has previously been provided to our board members. Chair will now entertain a motion to accept that rezoning hearing package with the findings of facts and the legal advertisements into evidence.
So moved.
Motion. We have a second. Second. All those in favor say aye. Aye. Opposed? Motion carries. The rezoning hearing package with the findings of facts and legal advertisement will be marked and included in the record for today's case. At this time, we're going to ask our court reporter to please swear in members of the staff.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God, and so you do affirm?
I do.
All right, thank you. We'll ask each one of you as you present, please state your name and position for the record so everyone knows who you are. Board members, we've previously qualified all of these staff members to offer expert testimony in the area of land use and planning. Do any of you have any questions regarding their qualifications or their ability to offer that expert testimony in land use and planning? Hearing none, the chair will recognize these individuals as experts in the area of land use and planning for the record. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, they are less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments are limited to the evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form and submit it to the staff members. And this will be for either case if you plan to speak in the quasi-judicial hearing, or if you speak in the Planning Board meeting, we'll still need you to complete a form to speak, please. They're located at the back of the chambers. You will not be allowed to speak unless we have received a completed form. Please also note that only individuals who are present and give testimony on the record will be allowed to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented to the Board of County Commissioners. Therefore, all testimony and evidence must be entered today. The Planning Board will provide a recommendation for each rezoning request to the Board of County Commissioners. They will then review the testimony, documents, exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek a judicial review of that decision must do so in a court of competent jurisdiction within 30 days that the BCC either approves or rejects the recommended order of the Planning Board. All written or oral communications outside of this hearing with members of the Planning Board are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as in BCC Resolution 96-13. As the case is heard, I will ask any board member that has been involved in any ex parte to please describe the communication and identify themselves. There are rezoning requirements, criteria, as required by Section 2-7.2 of the Escambia County Land Development Code. The Planning Board's recommendation to the BCC shall consider consideration of the following 5 approval conditions. These approval conditions show that the applicant has the burden of presenting competent, substantial evidence to the reviewing board, establishing that a requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area to which the uses and conditions must be considered may vary for those uses and conditions and is not necessarily the same as required in the mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. Consistent with the comprehensive plan, the proposed rezoning is consistent with the future land use category as prescribed in LDC Chapter 3 and with all other applicable goals, objectives, and policies of that comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment, as it is today, that will be first transmitted for state agency review. The proposed rezoning is consistent with the proposed FLU and conditional to its adoption. Consistent with zoning district provisions, the proposed zoning is consistent with the purpose and intent and with any other zoning established provisions prescribed in the proposed district in the chapter. Compatibility with surroundings. All of the permitted uses of the proposed zoning, and not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped property shall be considered the permitted uses of the applicable district. Compatibility is not considered with a potential conditional use or with any other non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities that are currently protected under fair housing laws. Appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character to the adjoining districts, or the differences within those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interest between the isolated district and the adjoining lands. And lastly, the appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are such a degree and character that it is in the public's interest to allow new uses, densities, or intensities in that area, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create sprawl. At the beginning of the case, as long as there are no objections from the applicant, the staff will present some location maps as well as photography for the property. Then we will hear from the applicant and any witnesses that they may wish to call. Then we will hear from members of the public who have completed a speaker request form. So we do have one case today, and we're going to now pause the planning board rezoning hearing, and I will hereby open the Escambia County regular meeting for August 3rd, 2021. As noted, we do have a quorum. And do we have proof of publication of this meeting?
Yes, sir.
Did that publication also meet all of the legal requirements?
Yes, sir.
Okay, Chair will entertain a motion to waive the reading of the legal on the regular planning board.
So moved.
Motion, second.
Second.
Second, all those in favor say aye. Aye. Opposed? All right, members, you've been previously provided the planning board meeting minutes for the previous meeting. Are there any additions, deletions, or corrections to those? Hearing none, Chair will entertain a motion to accept.
So moved.
Motion, do we have a second? Second, all those in favor say aye.
Aye.
Aye. Opposed? Okay, motion carries. The hearing package for August 3rd, 2021 has previously been provided to all the board members. The chair will now accept a motion to accept the planning board hearing package and the legal advertisement into evidence. Motion, do we have a second?
Second.
Second. All those in favor, say aye.
Aye.
Aye. Opposed? All right, motion carries. So we will go directly into our first public hearing. We'll come back to these other agenda items at the end of the meeting. This is public hearing 6 Roman numeral 1, a public hearing concerning the review of ordinance amending Chapter 7, Policy Flu 1.13 of the Escambia County Comprehensive Plan 2030. And who will be presenting for the staff at this time?
Andrew Holmer, Division Manager, Escambia County Development Services.
Good morning, Andrew.
Good morning. So what we have here, for a little background, the state passed a House bill that was then passed through the Senate, signed by the governor, amending Chapter 163 of the statutes, and that's the section that we work with concerning development and growth. What it does is it requires local governments to adopt a private property rights element into our comprehensive plan, and we have a very specific time frame we have to do this within. So we were provided with essentially a format, a text, man, I'm having a brain problem today. An example here, use this example. It's got everything that they need, that the state requires for us to put into our plan. Once it gets adopted and we meet those timelines, then if the BCC were to direct the staff, we could always go back and look at it and add to it, whatever. But it's imperative that we get through what was adopted by the state. It's mandated we have to do this. Before we can start processing anything else, we've got to get this through and to them with just that format they want. So I'm gonna,
If I may, thank you, Drew, and I want to add this point. as
Horace,
well. Yes,
please
sir.
state your name and position for the record.
Horace Jones, Director for Development Service Department. I'm glad for Mr. Andrew Holman opening this up. He's going to be the lead on this. But I do want to say this, it is imperative, it is essential, absolutely necessary that we, as a county government, move this element. Because there are other projects in the queue that are waiting, that are essential for the betterment of Escambia County that we cannot do until we get these things, until we get this element passed. It's a state law requirement. They provide us the frame, they provide us the words, and with our direction, which came directly from our legal department, Ms. Kiel Johnson, she worked very, very wholeheartedly making sure that we get this item in today so that we can move these things. They are our counsel, and this is why we're petitioning the planning board to review, to make a recommendation, so this can move forward, so we can get this to Tallahassee. They can basically loose us to start doing other things that's gonna be coming before this planning board and the BCC as quickly as we move this element to Tallahassee. It's mandatory.
All right, thank you, Horace.
pull up, can you pull up the ordinance, please? There we go, go down. All right, if you can zoom in. Sorry, there we go. Okay, so board, what we've got here, and I'm highlighting it on my computer, which is not connected to that one. Okay, just like any other chapter in our comprehensive plan, we start off with a title. We have a title, and then goal of what it's going to be. So you see these 4 items right here, and I will go through them one by one. In fact, it's short. I can read through the whole thing. Let's do that. Chapter 17, private property rights element. Part 2 of the Escambia County Code of Ordinances, Comprehensive Plan 2030. This is Chapter 17, the private property rights element is hereby created as follows. The purpose of the private property rights element is to ensure that private property rights are considered in local decision-making. Goal. It has one goal, which is the statement of rights. The following rights shall be considered in local decision-making. 1, the right of a property owner to physically possess and control his or her interest in the property, including easements, leases, or mineral rights. 2, the right of a property owner to use, maintain, develop, and improve his or her property for personal use or for the use of any other person, subject to state law and local ordinances. 3, the right of the property owner to privacy and to exclude others from the property to protect the owner's possessions and property. 4, the right of a property owner to dispose of his or her property through sale or gift. So that's the basic framework. State passed. That is what we have to adopt into our comp plan immediately.
Okay. As presented, I know, Horace, you've testified, and Drew has as well. This has been reviewed by legal for sufficiency that it matches the state's requirements for the comprehensive plan.
Yes, it has.
Okay, so all of these, and do you foresee that there would be any need to add anything to this? This is the minimum that the state requires?
Yes, it is. And at this point, we don't see any need for any additional language to be added at this point. Now, as Drew stated earlier, if there is a desire, a wish, after it has been blessed and vetted through Tallahassee and approved, if there's a desire to review this element again, like we do any other element, we can do so. But at this time, staff do not see any need or any direction to require any additional language. It has been vetted thoroughly and appropriately and sufficiently with our legal department, who provide us with some excellent professional guidance. Thank you, Kim. Plug.
All right, thank you, Horace. Do you have any other witnesses or anyone to testify? No? Okay. All right, we have members of the public who have signed up to speak on this, as well as the rezoning. And we're just going to go through these. Let's start with Ms. Meredith Crawford. I'm sorry, Drew.
That's for the future land use change. This is the private property rights element.
She signed up to talk for private
Oh,
property rights.
okay.
I signed up on this one as well.
Sorry.
Good morning, Meredith Crawford, 125 East Intendencia. I would echo what Mr. Jones has just stated and ask that you do move this today. I am one of the representatives of a client who has a small-scale amendment that you heard at your last meeting. You approved it. Unfortunately, we are not being allowed to go to the Board of County Commissioners this week because this is not yet in your comp plan. So it is holding up progress. It's holding up development. The purpose of the comprehensive plan is guidance. You know, this is not an enabling ordinance. It's simply to put the county and any applicant on notice in the future that they must, in future applications, address the impact of their ask on property rights. I believe this is sufficient. And I only signed up to speak because I understand there is someone who may be asking that you delay it. And if that be the case, then, you know, if they have suggested or proposed information that you would consider today, including, you could do an errata here and now, add a sentence if, you know, there was something that just you felt it had to be. But I am asking and feel that this is sufficient. It covers property rights, and we're asking that you go ahead and move this forward so that development that's pending in the county be allowed to continue to proceed and not be further delayed to come up with some, you know, perfect or magic language. Thank you.
And let me add to that, as Ms. Meredith Crawford, I do want to say this as well. There could be some additional language that was submitted yesterday, some words, but staff has not had the opportunity at all to vet it or discuss it with legal to think about it. And that would be the most appropriate way to do, to give staff the opportunity to vet it and to review it with legal. So of course you can hear it, and if you feel like it's necessary, that it can be added quickly or whatever. But again, staff has not. So therefore, staff is, again, petitioning this board at this time to move forward with what is written and what is presented to you today.
Okay, so just to kind of help this along, because there is an urgency of this moving forward, if individuals have items that they may want to change, they can be considered, but we may just come back at a later date and consider those changes where we could go ahead and send this in as not to hold up the current projects. This is meeting the basic minimum of what the state is requiring, and then if the county wants to or citizens want to propose other changes, we could come back for an amendment at a later time. That's what you're saying, okay? All right, makes sense. All right. Our next speaker, Mr. Frank Westmark. Good morning, Mr. Westmark.
Elizabeth has generously donated her 3 minutes of time to me, so if you'll stop waiting until you get that before you start the clock.
Okay.
The language you were looking for, Drew, was model. That's what the legislature has done, is produced a model for you, and it's a bare bones model. I appreciate the urgency that Meredith Crawford expressed and that Horace Jones expressed. And,
Excuse me,
I
Mr.
don't want
Westmark.
to hold up the action of the board here.
Hold on just a moment, Mr. Westmark.
If you could, or if you could turn him up a little bit, I am really struggling with him.
Okay.
I normally hear him pretty well, but I'm struggling today.
You having a hearing problem?
Yes, sir.
Yes,
I can
and
speak
it's
louder.
not your fault, it's mine.
Testing, 1, 2, 3, 4, 5. How about you got good, Gary? Okay, all right. Okay. The private property rights language that is recommended by the staff is good. The model is okay, it's good. It's just too weak for an element to the comprehensive plan that requires a whole new chapter in the comprehensive plan. That's a big deal. The new law provides the bare bones baseline model language, but the bare bones are a little short of teeth, and that's a problem. The staff is trying to serve you guys chicken soup when you really need a 32-ounce porterhouse. The law allows you to write your own element, and you don't need to do that. We recommend you approve the staff language, provided you strengthen it by adding the clear and unambiguous property rights protection language in the state comprehensive plan. It's very brief. Section 187-201, subsection 14, Florida statutes. We have incorporated that language in section 3, page 2 of the proposed ordinance for your review. That is legally vetted language, has worked effectively in the state comp plan for 30 years. The heading is localized for Escambia County, but it says basically Escambia County shall abide by the requirements of the State Comprehensive Plan, Section 187-201. Number 1, protect private property rights and recognize the existence of legitimate and often competing public and private interest in land use regulations and other government action. 2, provide compensation or other appropriate relief as provided by law to a landowner for any governmental action that is determined to be an unreasonable exercise of the state's police power so as to constitute a taking. 3, determine compensation or other relief by judicial proceeding rather than by administrative proceeding. 4, encourage acquisition of lands by state or local government in cases where regulation will severely limit practical use of real property. That's it. One little addition to what you've got up here, right in behind the language that you have right here, maybe a little reformatting, and you've got a great element for the comprehensive plan. That language that I just read you, by the way, is identical word for word to the private property protection section of the Escambia County 2000 and 2020 comprehensive plans. That language is also legally vetted, and it's served the county well for almost 20 years. The staff is very familiar with it. Removing that language from the county's comprehensive plan in 2011 cleared the way for adoption of the sector plan with all of the unintended consequences, including the 50% rule that you've heard me talk about almost endlessly. Return that tested and true language as an element to the comprehensive plan will slam the door on future private property abuses. Property owners are entitled to that protection. Our recommended amendment, brief as it is, does not change a word in the proposed ordinance. It merely adds 4 brief paragraphs at the bottom of what you've got up here from the law itself, actual law itself from the State Comprehensive Plan. The additions comport with the 4 provisions in the model ordinance without conflict or redundancy. With that, I think I'll leave it at that, except to point out to you that we have reason to believe that the Board of County Commissioners would look very favorably upon such a recommendation that you might make today. And we recognize that this involves a little inconvenience to the staff, but just simply adding 4 short paragraphs to what they've got should not delay the furtherance of the recommendation to the Board of County Commissioners on Thursday. So I would ask that you approve this subject to adding those conditions that are in the State Comprehensive Plan. make sure that we've got a good element to begin with, that we don't have to come back and revisit this multiple times with uncertainty. Any questions?
Board members, any questions at this time? All right. Thank you, Mr. Westmark.
Thank you.
Horace or Drew, any response? Some of the items that he's discussing have already been in the code. I know you haven't had a chance to review his suggestion for legal competency and everything, but you have any response?
Obviously, with any proposed change, we're more than willing to discuss it, review it, and bring it to this board for a discussion item. At this point, we've got our marching orders to proceed quickly, as fast as possible to get this model, thank you, adopted as per state statute.
Okay. All right, our next speaker is Mike Floyd.
I'm here on the Inner Island zone. Sorry if that wasn't clear on my form.
Oh, okay, I'm sorry. I thought I had you. Okay. Cheryl, is it Lively? LaValley?
I'm in a rarity as well.
Okay. All right. Yeah. Okay, is there anyone else in the room that wants to speak on the planning board public hearing for the changes to the comprehensive plan that we've just heard from Mr. Westmark? It looks like everyone else here is more interested in the quasi-judicial portion of the hearing. So anyone else for this public hearing wish to speak? All right. We will hereby close public hearing, public comment on this hearing. And at this time, board members, open it up for questions. If someone's ready to make a motion, consideration of anything at this point.
Yeah, I have a question. It's for legal. Could we insert Mr. Westmark's language and vote on the ordinance today?
You all have the authority to make a recommendation to the Board of County Commissioners that the additional language be included, and the Board of County Commissioners could make that determination at their meeting, yes.
Okay. Well, then I'm going to move that we insert Mr. Westmark's language into the ordinance.
And I do say this wholeheartedly, respectfully to Mr. and Mrs. Westmark. Again, as Drew stated, we can come back to discuss this because just those terms, and I'm not a lawyer at all, just those terms could need to be reviewed and discussed thoroughly. When you're indicating provide compensation, and this was, if it was in there, this in the state comprehensive plan. I am not that familiar with the state comprehensive plan. I'm familiar with our county comprehensive plan, and we would need the opportunity to review this and see the context of this language. And at this time, I strongly suggest that staff nor legal has had the opportunity to review this. One change like this can throw one word in the ordinance change, can cause many problems. So not that the language is not good, not that it's not necessary, but at this time, let's move forward. We would suggest moving forward with this so we can give the staff the opportunity to review this and really discuss it with our legal department, because you're dealing with takings and providing compensation and all of those things. Those things come with a lots of great deal of sometimes case law got to be looked at and other things got to be looked at when you start talking about providing compensation. Again, not that it's not necessary, but those are legal things that must be reviewed and discussed with legal thoroughly and completely, because they can be very inflammatory.
Could we not pass it, and then if there's a problem, change it? I mean, you've got till Thursday to get ready for the board, right?
The board is already done. It's already in the hands.
It's already
of-
published?
Yes, sir.
Yeah.
Yes, sir.
I'm still in favor of my motion.
Yes, sir.
I'll second it.
Okay. We have a motion and a second to include Mr. Westmark's language in the recommendation to recommend approval and include that language to the county commissioners. Discussion before we take the vote?
Just looking at the actual statute of the Florida statute, it is under the property rights. And the goal and the policies are laid out exactly word for word from what Mr. Westmark has suggested. The only difference is instead of number 1 being protective property rights and recognized existence, that is actually a goal. And then after that is the policies 1, 2, 3, as he has suggested. So that is actually in the statute. So I agree that this has already probably been vetted out, and I agree with the recommendation.
Okay. Other board members want to weigh in? Jay?
Mr. Speaker.
I'm
This
sorry,
is Tim.
Tim. I'm not used to having a voice from above here, buddy. You've
sorry,
taken
I'm
on a
sorry.
new title here, I think. Go ahead, buddy.
I just wanted to, my understanding of what Ms. Kia explained to our board member who put forth the recommendation is that we can suggest that these be added to it, and it's up to the Board of County Commissioners. So I don't quite understand why Mr. Jones feels as though by adding this, there's some fear that it'll falter due to our passing of it changed. I don't see why we can't go forward with it, pass it, suggesting these be added, and it's a suggestion. Am I mistaken? Am I missing something, Kia?
Mr. Powell? Yes, I was wondering where the voice was coming from myself. It's not that it's the fear, it's the process. These ordinances, they are vetted, and it was reviewed sufficiently. This model ordinance was reviewed sufficiently with the legal department. We just got this yesterday. And again, and I know these terms are, they need to be thought out sufficiently and considerably. And so for us to try to get this included now, I would think, from my personal experience, and I've been doing this for over 20 years, that it would not be as sound as it could be with this planning board coming back, looking at it, and with legal and guidance and discussing it thoroughly. So yes, I think that is a good way to, we make additions all of the time. But to get this, try to get this incorporated in, I think it is against the processes and the procedure. Not that it's not a good idea, but at the last minute, things need to be discussed more thoroughly because there could be some unintended consequences that could occur. And then we'll be being back trying to undo something that was not discussed as sufficiently as reviewed and vetted properly as it should have been, especially when you're talking about compensation and those things. You have to be very, very careful. And I'm not a lawyer, but I did some legal research when I was in college 10 years ago. So we have to be careful.
So, Mr. Chairman, there are concerns with this language from a legal standpoint, especially with respect to the providing compensation, because if you read that paragraph, it's saying that Escambia County will provide compensation or other relief as provided by law to a landowner for any governmental action that is determined to be an unreasonable exercise of the state's police power. So that's saying if the state comes in and takes someone's property in Escambia County is agreeing to provide compensation in that instance, and that's a concern from a legal standpoint. And we do plan to explain that to our Board of County Commissioners why that is a concern. So if this sort of language were to be added, I would prefer that it would be brought back to a separate meeting so we can discuss this in detail, because there are implications for adding this type of language, and there was a reason for removing this language to begin with. We previously had it in our comprehensive plan for decades, but we removed it, and the state did approve our comprehensive plan as written.
Mr. Westmark, come forward again, please, sir.
Yes, maybe I can shed a little bit of light on that. The, the language that we're suggesting here, the staff abided by for almost 20 years. It's word for word. So there's not much more legally vetting and not much more legal vetting that needs to be done when you've abided by something for that length of time. Now, the language was removed in 2011 without your knowledge. And it was removed because they couldn't get the sector plan adopted with that language in it. The 50% rule could not have survived in that language. And that's what we're trying to do here, is to prevent this kind of overreach of regulation from happening again. And if we just simply insert the language back into the comp plan that the staff is familiar with, Ms. Johnson is not, because she wasn't here at the time, but Mr. Jones is, so is Mr. Homer and the rest of the staff. There's no mystery here. There's nothing new. Everything is as it was, and it really needs to go back in the plan. And there's no reason why that I can see that it shouldn't be done now and move forward with Board of County Commissioners, which is what everybody wants.
And as far as change, to me, it seems like it's 6 of one or half dozen of the other. If we move forward with the existing ordinance, then we got to come back to change it to get what we want. What's the difference? Why not go ahead and move with the ordinance we want?
Sir, we'll need you to go back to the microphone. We're recording the proceedings here.
Mr. Chairman,
Yes, ma'am.
and just a point of clarification, I was not here in 2011, but I have familiarized myself with the previous versions of our comp plan. The language provided by the Westmarks is not word for word from what was in our comp plan previously, specifically the subsection 2 with respect to providing compensation. The language that was previously in our comp plan had a determination of whether there was an unreasonable exercise of police power. It did not say an unreasonable exercise of the state's police power. So there is some differences in this language, and we would like an opportunity to review it.
Yes, and that is why we don't. That's why it's not sound planning to take ordinances like this at the last minute. That's all we're saying. Not that it's not, may not be good, but for any cases like this, our legal department has to defend us. So if they are not comfortable with the language as written as is, I would suggest strongly that we can come back for another discussion, because we definitely appreciate the Westmark valuable input and that they do provide the board, the planning department with. Again, let me say as well, I was here in 2011. Again, sometimes facts are not as they based upon. I don't recall many of that discussion regarding that. So it was not just taken up because we moved the sector plan or the DSAP or the 50% rule. Those things, many of those things came afterwards. So I would suggest by legal that we do sort of come back, discuss this, don't rush it, because there are some elements that can cause some other things that may occur, unintended consequences. That's all I'm saying. Let's move forward with the model. And I do believe that, I can't speak for the legislators, that they probably looked at those same things, but they came with this model because this was the best at this time, that they want to get this and come back, and like they do many legislators come back every year and revise things. And if they feel like that's necessary, they'll come back and challenge us, the states, again, to add additional language. So at this time, I strongly suggest that we move forward with the draft as written today, based upon our guidance from our legal department, and which the planning board, which our legal department guide you all as well in trying to make sound planning decisions.
In my opinion, you fellows have one good shot at this thing this morning. If you don't get it done now, it's going to be difficult down the road. I have every confidence that this staff can reconcile any little minor issue in whatever the language is. All we want to do is to see the language that was in the 2000 and 2020 comp plan restored, so that we don't have to go through some we've had all these opt-outs. Everything has been about property rights. We're trying to get that straightened out. Now we're done with the opt-outs. If we can get this property rights thing cast in stone so it can't ever happen again, then we can break out the champagne. But we don't need to be arguing about this for the next 6 months. Now is the time.
Mr. Fears, did you want the floor?
I agree with Horace, just probably not in the way he's going to appreciate. He stated that it's not wise to move forward erratically and just add something in. I feel like that's exactly what is happening to us with this one. We're on a timetable. We have to get this templated element in, and we're pinched. And I sympathize with Mr. Westmark's remarks that this might be a way of boxing out the very language that we're talking about adding, and it could become complex to argue for the next 6 months to add. So I guess I need help understanding that if we make a recommendation, or if we make a recommendation today to pass as is without any note at all on recommending the addition of the state statute language, are we taking a step forward that's irreversible and boxing ourselves out from getting that language later?
No, we are not. No, sir. No, we are not.
Okay, Mr. Jones, if that's the case, are we boxing ourselves out from changing it and taking the language out later?
This is a state law. So, I mean, you cannot, this is an element that's required by the state legislation. They told us we have to include this. So this almost like, please correct me if I'm wrong, that this mandatory language that must be included in our comprehensive plan. This language as is. According, of course, now you can find, they don't say this is a model, but we got to have a private property rights element, and they provide a model for us to write.
I'm just asking you, if we pass the language as Mr. Westmark proposed, are we boxed out from changing it later?
No, you're not.
You wouldn't be boxed in, but it would be more difficult to remove it than it would be to adopt it, because with any comprehensive plan amendment, you have to have the necessary level of data and analysis to make these kinds of changes. Because the language as is what is required by state law, the level of data and analysis that is required is bare minimum. If we were to put this new language into our comprehensive plan and then wish to remove it, it would be a heavy lift.
You know, I tend to agree with Horace. This is a deliberate planning process. It's not crisis action planning. And if it's a good idea, the additional language, if it's a good idea today, it'll be a good idea a month from now or 2 months from now, and staff can evaluate that. It'll give them some time. So again, it's a deliberate planning process. If it's a good idea today, it'll be a good idea 2 months from now.
Well, I'd like to chime in here and say I have a great deal of respect for the Westmarks. I know they always do their research and come up with information. My concern with the current motion that's been seconded on the floor is it sounds like the county would be responsible for compensating individuals for something that someone else could possibly do. And I have a great concern about that. I'm not concerned about there being the ability for the county to compensate someone if the county does something wrong, but if the county is compensating for something that the state is doing wrong or another entity is doing wrong, I do have a little heartburn with that. So that's one concern, and I'd like to explore that more with with our attorney. And then you also said something that this is not the same language. I know there was only a little change, but as Horace said, I think sometimes one word here or there can make a very big difference. We've seen that over the years. You know, one of my things I dislike the most about writing code is when something says recommend. It's either you approve it or you don't. If you recommend or it's up for consideration, it leaves such a gray area. So, Key, I'd ask you to first speak to the compensation of the county having to compensate for what others do. Is there a legal basis behind that?
Yeah, the concern is twofold with that particular paragraph. So the prior language that was in our comprehensive plan, it said that a landowner, provide compensation or other relief as provided by law to a landowner for any voluntary Escambia County action that is determined to be an unreasonable exercise of police power so as to constitute a taking upon adoption of this ordinance. So the specific event that would constitute a taking would be the adoption of this ordinance. And the exercise of police power would be the county's exercise of police power. Whereas the language that's being proposed, it's referring to the state's exercise of police power. So if the state comes in and takes county property, we're saying that the county is going to compensate people for that. And also, it's not just a taking that is affected by the adoption of this ordinance, it's any taking. Because the sentence stops at the word taking and it doesn't say upon adoption of this ordinance.
So I have a little bit of concern about that, and I want to explore one more thing, and Horace, you may be able to help with this. Mr. Westmark indicated that a clause was removed from the comprehensive plan without the planning board knowing about it, I believe is what he said.
Respectfully to Mr. Westmark, as Mr. Brisker, you've been doing this a long time. If there's any changes that were done to the planning board or the comprehensive plan, it would have came before this board. That was the process, especially under the old DCA rules. And we was under the old DCA, it would have came back to the planning board and review and discuss with the planning board before any changes or anything that should have been removed from any planning board ordinance or the comprehensive plan ordinance. So that statement is not correct under the old process.
Would it be fair to say that it possibly was removed when we considered the sector plan to allow for that to go forward? I know Mr. Westmark's concern is that it wouldn't allow for the 50% rule, but would that have had an impact directly on this?
It's hard, Mr. Brisker. You are asking me to get into a time machine? and it's hard to answer that question because of the many deals and meetings with the sector plan process and all of those things. So I do not want to underspeak or overspeak, but I do know this, that the DSAP rules and the sector plan came later. The 50% rule did not come during the adoption of the sector plan. That came later. So we need to really make sure we keep that in mind. And that's another, we could discuss that. We will have ample opportunity to discuss the sector plan and process and what occurred back then in the very near future.
Okay, now let me explore one more item here. This is procedural item. If we move the ordinance, it gets enough votes to move forward as a recommended order, including the language. The county commissioners can alter it at that time and remove that, and you said there was a problem with procedural doing that process. So let's say the planning board says, yes, we want to include Mr. Westmark's comments because we think some of them are pertinent. I'm not sold on all of it, but some of it is pertinent, I believe. But we will have to work close wholeheartedly with our legal department to make sure that, because this is everything got to flow in what the board approved and BCC and ordinances and adoptions, it would be completely how everything flows with them. It may be a separate, it could be in a writer sheet.
it's really not that clean as people think when it comes before the board actions and what they can approve, especially when it comes to legal ordinances. So again, staff would suggest, take the draft ordinance as is, what was approved, we can come back and we can discuss this sufficiently, especially with the statements that our legal counsel just made. When you're doing takings, you have to be extremely careful because I know that's really case law driven.
Okay. Go ahead, Walker.
Chime in. I think what the Westmarks have brought us is, I think something we definitely need to look at. And I think to Horace's point, I don't know, and to your point, does that need to happen today when we've all just kind of got made aware of this? So for me, I think the best thing to do is to move forward with what we've got and then instruct staff to bring this back in a month from now when we can look at it. And because I think I think they brought forward some good recommendations of some things we need to look at, but let's make sure that we've got our due diligence in order, and instead of trying to force this thing through today, it just seems a little silly at this point to me.
But without changing language and in a motion, without recommending a change, is there anything that we can do to message the BCC that there's an expectation of revisiting immediately?
I think while this is live today, it is definitely being viewed by probably some of the people downtown.
Yeah, but
I think the
legally,
message legally.
legally in the motion.
It could be part of the motion. It could be a recommendation that the Board of County Commissioners direct staff to review the additional language and bring it back to the next planning board meeting.
Absolutely.
I think I would support something like that, because I
That's
think
about the best
language
compromise
Right.
from the parties that.
important. I just have concerns that there's some things that aren't exactly matching up
And
in
we don't
there.
want to jeopardize the whole thing.
Okay,
I want
go ahead, sir. Mr. Westmark?
Going back to what Mr. Jones said, I think I know you well enough, Mr. Briscoe. I know you're a property rights guy. If you had been told that the county staff was removing the property rights section from the comprehensive plan in 2011, you would want to know why. My guess is you would have hit the ceiling. Well,
That's
neither did-
specifically why I just asked Horace, because I do not remember a discussion about it. Of course, that's 10 years ago, so.
What Commissioner Barry was on this board at that time too. He didn't know anything about it. The members of the Board of County Commissioners, all 5 of them that approved it, didn't know a thing in the world about it. It passed in 500 pages of documents with the 2030 comp plan and the sector plan all together, and that's how these things happen. You have a little bit of something here in a 500-page document. You guys don't have time to read all that stuff. You can't evaluate it every bit of it in there. Here's the problem for today. If we don't, I said a while ago, you get one crack at this thing. If we don't get this done today, then to do what we really need to do and put some beef in the plan as an element, then we got to come back and pursue another comprehensive plan amendment. Right?
That's the process.
What, if we don't do it in this comprehensive plan amendment, then we got to come back and do it in another comprehensive plan amendment. Well, now this is a can of worms. The simple thing, I know the people will resist this because it takes a little extra time and effort for them to get it squared away for the Board of County Commissioners. I understand that. But, you know, I'm one of about 200,000 property owners in Escambia County that have no clue about what you fellows are about to vote on here today. And I'm trying to stand up for not only myself, but for them as well. And so this thing needs to be done right. If it causes the staff a little inconvenience, well, it causes them a little inconvenience. There's no tremendous urgency about even doing this today. I recognize Ms. Crawford's position and her client, but the law doesn't say you have to do this today. The law allows you to do it with the next adoption of the next comprehensive plan. Horace has control of the agenda of both this board and the county board. This could go before the county board next month. It doesn't have to go on Thursday. What we've got here is sort of the bum's rush. And I don't understand why we have to be so rushed and why nobody has no knowledge about what is taking place here today other than we happen to find it on the board's agenda. That's why we're here. Otherwise, we wouldn't be here. So it's critical that you get it done right and you get it done today, because I don't think you're going to have but one crack at it.
Well, I would say that I think what I heard from some of the board members, and they can all speak for themselves, is that we respect and agree that some of the things that you've brought forward are important to this, but we also don't want to be rushed or force the legal process to be rushed to adopt it that way, and keeping in mind that there is a time frame on it. I would be in favor of supporting moving this forward with a caveat that these other items must be considered by the county attorney's office, and it must come back for another hearing to amend the items that can be. I still get hung up on some of the language in there, Mr. Westmark, where the county is compensating for other people's actions, and that it's not exactly the same language we used before. So I'll let you speak to that, sir. Go ahead.
The county would not be compensating anyone for any state actions or any other kind of thing. The only thing that the county would have to compensate somebody for is if the circuit court ordered them to. So we're not talking about some administrative compensation here. We're talking about the exact same language that was in the 2000 comp plan and the 2020 comp plan. It's very clear, very straightforward. These folks know all about it. And I put the state language in there just so you get the feeling for the fact that the state comprehensive plan has the exact same language that our comp plans had before the language was removed. So if there's some conflict between the state language and what the county had before, then the state language needs to get out of the way. So, the lawyers can do that with a stroke of a pen. That's very easily done. And I realize there's some misunderstanding, and anytime a problem comes up that the staff doesn't want to deal with, it's usually got to have legal consistency, which means we're going to have to delay. And the problem here is, I'll say again, if we delay, which is fine with me, you don't really need to vote on this today. It's kind of like the sector plan. You have a workshop on that next month where everybody gets an opportunity to come in and have something to say about it, take some testimony. This is all of a sudden, boom, and it's right through the system, right through to you today, right through the county commission on Thursday. Big rush, no testimony, nobody knows what's happened.
Mr. Chairman?
Go ahead, sir.
Yeah, it's my motion, and right now I have a board member that's seconding it. I'm hoping they stick with me. My personal opinion is, if I'm going to be rushed to do something without being able to address these issues up front, I'd rather insert the language and then come back and fix it later if it needs to be fixed. And so I stand by my motion, but I can also count votes and respect my board members. And so I'd like to call the question so we can move forward one way or the other.
All right.
Mr. Chairman, before there's a vote, I would request a friendly amendment to that motion to provide that if we're going to recommend that language be inserted to the ordinance, that it be the language that was previously in our comprehensive plan and not the language that has been proposed specifically by the Westmarks. Because this language is detrimental to the Escambia County.
I'm fine with that. I move to amend my motion. I'm not sure though. Are you Robert's Rules of Order?
You can amend the motion, and we'll ask Mr. Rushing if he's going to second the update, which is to accept what was previously in the comprehensive plan of Escambia County and was removed, we think in 2011 is when we think it was removed. But that language had been accepted at previous time. Okay, Mr. Rushing, would your second stand on the amendment?
Yes.
Okay. And now we're in discussion, and I will call the question. I just had one more statement I wanted to make. Mr. Westmark, again, like I said, I respect, the information you bring forward. I know quite a bit about the comprehensive plan and the land development code because I'm coming up on 18 or 19 years of doing this, but I'm not an attorney. And so I regularly rely on our board attorney when it comes to legal issues. And so that's where my concern comes in is making sure that we do that right, because I don't want to try to commit the board to something that's not going to be legal. That's where my main concern lies. Having said all of that, I also know that if we move it as presented, the commissioners can decide to not accept that portion of it and still move it forward. Is that correct?
That's correct.
So the decision would really then be theirs to whether to include that language from the previous comp plan or not.
Yes,
So
that's correct.
it wouldn't necessarily stop it and have to send it back here. They could vote on it at their meeting, just removing the information that Mr. Sammons has suggested. Is that correct?
Yes.
Okay. So that seems like a logical compromise, so to speak. I know the county is not really in favor of that, but that would put the decision to the commissioners, who are our elected officials and who get paid the big bucks to do this stuff. We're volunteers that try to sort all this stuff out and work our way through it. So with that, we have a motion and a second to approve moving the item forward with the inclusion of the language that we think was removed in 2011. I think we need to, before it goes in front of the commissioners, clarify exactly when that language was removed if this motion passes. Any further discussion from the board members? All those in favor say aye.
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 Opposed?
Nay.
Okay, motion carries. Mr. Pyle, you did vote in favor, is that correct?
Yes, sir, that's correct.
Okay, and we had, Mr. Ingwell, you were the lone nay vote on it, is that correct? That's correct. Okay, I just want to make sure that we got it on the record, what everybody voted, since we're using conferencing at this point. Okay. Do we need to address anything additional in planning board before we go back to our hearing?
Small scale.
Small scale.
We have to go, that's what I was thinking, we have to
Yes.
address that one
Item
next.
2.
Okay. Okay. So, thank you, Mr. and Ms. Westmark.
Absolutely.
All right, Drew, when you're ready?
Yes, sir. Okay, so the next item, this is another one of these driven by the state. Basically, what this ordinance is doing, and it's important that we go through this one now before we hear the case coming up. This one, in the past, a small-scale future land use amendment was limited to 10 acres or less. The state has now bumped that up to 50 acres or less. 50 or over is large scale. So we need to have this ordinance, a recommendation on this ordinance before we can address one that's coming up that's 32 acres as a small scale.
And so the ordinance basically stays exactly the same. It's just the number of acres
That is
for the
correct.
amendment goes from 10 to 50. Is that correct?
That is correct. If you could pull up the strike-through underline portion.
Drew, while you're doing that, do you see any negative impacts on this? Obviously, the state picked this up for a reason. I know that the small-scale amendments are complex, and the reason there's the small scale versus the large scale is there for a reason, but maybe you could just give the board a little more background on it.
So the small scale is handled locally. It does not go to Tallahassee for their review and approval through DEO and other state agencies. The downside, there's always unintended consequences, be they good or bad. At this point, it's kind of cloudy to see what those could be. Obviously, the state legislature saw this as a positive. I can't think of a negative offhand, but will not guarantee there couldn't be.
Put you on the spot, so appreciate you responding. All right, go ahead, sir. Did you want to go through?
Oh, yes, sir.
anything
So
else?
what I
Okay.
was going to show you, and I'm using the wrong mouse again. Here's the only part where there's a change on that. Line 38, we changed 10 to 50 in both spots. So the strike-through is coming out, the underline is going in.
Okay.
And that's it.
Is there anyone to speak on this ordinance? I don't think I have anyone signed up to speak on this one. Yes, ma'am, if you'll come forward, please. Did you sign up one of the forms?
I did.
I'm sorry, I might have missed you. There's some
I
folks
signed
put-
up for both items.
Okay, that might have been, tell me your name, please.
Cheryl Lively.
Okay.
By the way, Mr. Live used to work for the Board of County Commissioners many years ago when I first, always was pleasant and professional.
Thank you very much.
Mr.
Thank you.
Torres,
Welcome to you.
Thank you.
I'm sorry?
I just want to make it clear that I have the timer on my computer for them to view, because if I have it on this, it's on Microsoft Teams, and we won't hear it. So
Okay.
I have it on here.
So for those of you that this is your first time in the chambers, we do have a time limit for speakers. And that's just because a lot of times, as if today, we have a large crowd and we want to give everyone an opportunity to speak. So if you hear the beeper going off, we'll ask you to wrap up your comments as quickly as possible. The board did vote some time ago to allow people to donate time. That's why Mr. Westmark got an additional 3 minutes, because his wife donated her time to him. Now, when we go back into quasi-judicial, and I'll state this again when we open it, you must say your information on the record, because if you don't say it at this meeting, it can't be repeated at the Board of County Commissioners. Now, we're still in planning board now, but when we go back to quasi-judicial, that's a very strict rule. They actually listen and read the transcripts, and if you haven't been on the record here, you won't be allowed to speak at BCC. So we'll make sure that we go through that. With that, if you would please state your name and address for the record.
My name is Cheryl Lively, 5677 Inner Circle.
Yes, ma'am. Please proceed.
My purpose is really to ask for clarification on how this change will specifically impact the rezoning request that will follow this for Inner Island.
Go ahead, Drew.
Okay. This ordinance, amending the size of what is a small scale versus a large scale, this would mean that the request coming up is 32 acres. That can be handled at the local level. It comes through the planning board and the BCC for their adoption. At that point, it's done. Without this ordinance, it would need to go to Tallahassee for their review through DEO plus every other state agency involved. So that's the difference. This gives the local control as opposed to state control.
So my understanding is that if this change is not adopted, then we have a little bit more oversight in the impact that will be imposed on us if the rezoning, if it's approved.
Okay, well, two separate things. Future land use change is necessary to do that rezoning, and I'm trying not to go into those two cases because those are separate items. If this ordinance passes, goes through, then everything can be handled as is at the local level. If this ordinance is not in place, then the proposed change to the conservation flu and the proposed change to conservation zoning will be tabled and go away, and we'd have to start over again from scratch and making a large-scale amendment and then go all the way through Tallahassee before any rezoning could take place.
Okay. So we as residents have the additional power of additional review if it's not adopted, if this change is not adopted. It has to go through, the county can't locally do it.
The county can't locally do it without
It would
this.
have to go through all of those reviews for additional conservation and environmentally sensitive property that the state provides.
Yes, it would have to go to the state for review as opposed to the county.
Okay.
Well, it would go through the county first for a recommendation, then go to the state for them to review.
But it would have to be reviewed on a higher level, on a state level.
It'd be reviewed for the same things.
Yes.
It's just different departments.
Okay. All right. Well, in that case, I certainly oppose it because I want that additional review. I want this conservation as a resident and the attention that goes to environmentally sensitive issues to be well thought out and reviewed by every level. So it is, if you haven't been out to Innerarity Island, it is a very unique, small, environmentally sensitive area. And this opens the way for a lot of changes that would certainly negatively impact the area and the community. So, thank you.
And without going into those cases, because we're not in those yet, that's the direction the county's going, or recommending. And this ordinance is a statewide thing. They're telling us to adopt into our comprehensive plan. And it doesn't just impact Innerarity Island. It impacts the entire unincorporated Escambia County, the changes to what is a small scale versus a large scale.
But a number of areas across Escambia County that have been, through the years, designated as environmentally sensitive areas could be opened up for development with this change at a local level.
Same as it would be without this adopted. It's just the amount of acres
Right.
at a time that go through.
That's right.
So it would still get the same review.
But that review changes with the adoption of this change in the,
All this is doing is saying the amount of acreage that's
Yes.
considered a small scale is now being increased.
yes.
And let me add something to Ms. Lively. And we are not, there are currently conservation principles and elements and statutory requirements and provisions inside the comprehensive plan and the land and building code that we're not changing. This is not changing those. So those concerns about the reviews, they're still in place. They still got to abide by our conservation rules that are in place and the comprehensive plan element and the land and development code. So we're not changing any of the provisions for protection.
But this change from the 10 acres to the 50 allows for the consideration at the local level without additional review by the state agencies.
That's the acres, yes.
Yes. And any of those folks from Innerarity Island that didn't sign up to speak on this issue will not be able to address the board unless they speak to you today. That's correct, right?
In this meeting, they can speak or not speak and still go to the county commission. When we go into the quasi-judicial, which is the actual rezoning, that's all recorded by the court reporter and recorded verbatim. That's evidence.
Okay,
In that
but-
case, the evidence is all that is transferred to the county commissioners, and so your comments go with that, and you can say the same thing you said in front of us, but you can't bring a whole bunch of new evidence into the county commission meeting. It all has to be presented here first, and then you can reiterate it at the county commission meeting, but you can't add things to it.
But they don't have to sign up for this issue to be able to speak to the board on this issue. Is that correct?
That's correct. As long as they show up at the county commission for a regular planning board hearing, they can speak. On the quasi judicial, they have to speak here first.
All right. Thank you
Okay.
so much for your time.
Let me ask another question about Drew and Horace for the timing of this. You've testified that this is a state requirement. Are they going to require Escambia County to adopt this? Is that, when we say recommended by the state, are they basically telling us that we need to update our comprehensive plan to this?
I'm not sure. I haven't seen all the language on that. The problem would be if we start sending stuff to Tallahassee that is over 10 and less than 50, they're going to ask us, why are you doing this? It's not a large scale, and kick it back.
So the comprehensive plan wouldn't be consistent with their
That's
rules
correct.
at that point?
That's
Okay.
correct. We would be inconsistent and,
So,
like I said, start all over again.
and I certainly don't mean this to be dismissive to your comments, because I understand your concerns, but if this was passed in this month's meeting and went through the process and was approved, and then 6 months from now, what the county is trying to do came before us as a quasi-judicial hearing, this would have already been in place at that point, and so we're bound to it. I mean, I think you were saying, this change needs to happen in our comprehensive plan. It's just a matter of whether it happens right before this case that we're considering or not.
Sure.
Is that fair to say?
Yes, that is
Okay.
fair.
Okay. All right. Anyone else on this particular issue? We obviously still have other cases that will recognize you if you've signed up, but on this public hearing, anyone else that wishes to speak? Okay, we'll go ahead and close public comment for this hearing. Board members, your thoughts on the changes, and members of the public that have spoken. I do have one question. It sounds like the concern is about environmental issues. What level does the Environmental Protection, DEP and such have on something like this? With it being, this is jurisdictional wetland area. I'm not trying to get into the case too much, but they have jurisdiction, so they're already reviewing that at the state level or at the federal level with DEP?
They would only get involved if something was proposed for development. Currently, nothing is proposed here other than to conserve the land as it is and clear up a few items with it as far as making it easier to maneuver. And I'll explain all that when we go into the next case.
All right, planning board members, here you go. Here's our chicken and egg syndrome again. All right, I'd like to hear some comments from anyone of what your thoughts are on it, or if someone's ready to make a motion.
I say we make the motion to approve the 10 to 50 as written.
Do we have a second?
Second.
Okay. Any further discussion? All those in favor say aye.
Aye.
Opposed? Tim, was that an aye or a nay?
Aye, sir.
Thank you, thank you. This is a little hard to hear sometimes. All right, so everyone here voted in favor? Okay. All right, so we have a unanimous vote to move that forward to change from 10 to 50 acres on that piece. All right. Anything else that we have to address? I guess we have to do we have to do the map at this point?
Yes, sir.
Before we go back over, right? Because all of it has to go as a package, right?
Yes,
Okay.
sir.
So now we're going into hearing, Roman numeral 3, public hearing concerning the review of the ordinance, and this is for the actual map, SSA 2021-02.
That is
Right,
correct.
Drew?
Yes, sir. So let me start with a little bit of background here. I'm not privy to all the background, but I'm quite confident folks in our audience could tell you the whole backstory. It's my understanding this property, there's multiple parcels, came into the county's possession as part of something to do with the water and sewer project that was going out there. Like I said, I don't have all that background information. But what it is the county now has these, and the way I'm describing it is selected parcels, right-of-ways, and greenways of North Shore 3rd Edition and North Shore 4th Edition, and portions of greenways. That guy sounds terrible. From North Shore 1st Edition and Inner Shores plats. There's multiple plats out there. Let me drop to the next. Can I? Yeah. So that's our location. So this is the zoning. The area in question is outlined by that red line. So the zoning was LDR. The current future land use out there is mixed-use suburban. And the proposed land use would be conservation. Once again, this is a future land use change. We'll talk about a rezoning later. If you would drop down one more, thank you. There's an aerial map of the site. So these parcels of land, these lots, these subdivision lots are undeveloped. And the area is currently gated off. It is strictly, at this point, a passive recreation type area, and that is the proposal for it to stay that way. As part of processing through this, I also understand that at some point this property would pass on to a nonprofit type organization to ensure that it remains in that conservation status. What we can do locally is change the future land use and the zoning to conservation. But then my understanding again was that it would fall under a nonprofit and ensure that it remains undeveloped. Now, as you look at the map, you see all the lines, rights of ways, there's greenways in there. It's rather unwieldy at this point to try to describe this property. Like I said, I'm saying it's selected parcels, right-of-ways, and greenways from multiple plats. What the county would proceed to do after this, or as part of all this, would be to vacate those portions of those plats so that we would simply have a meets and bounds description of one large parcel. Once again, conservation being the goal. That would make it much easier to describe and for anything else that would need to be involved in that property. So, yeah, I'm sorry. Yes, please go to the photos if you would. So, public hearings.
While you're
Yes, sir.
saying that, do you have a proposal of what that would look like in your presentation?
Yes.
I mean,
If you
okay.
go back up. So there we go. Proposed conservation future land use for that area right there. And
But
those interior lines would go.
All the interior lines would go away.
That would be correct.
All
Yes, sir.
the plats would be vacated. We would just end up with just basically a parcel designated for conservation.
That is correct.
Okay.
2 questions.
Yes.
It may have slipped by me real quick, but currently the county is the owner
That is correct.
of all these lots of record.
That is correct.
Okay, has there been any civil engineering performed on on this land?
Not that there would be beyond the original platting of the land.
Okay, so the roads are just dirt and there's no impervious, and is there sewer running through it?
I believe there is, once again, not our department, but a different department. There has been discussion, I think ECUA, there would still want to have easements across the property.
Okay.
for water and sewer. I don't believe it, and once again, the residents would have to help with this. I haven't gone and walked the entire site.
Yeah, the
so I
end
couldn't
question
tell you.
is, you remove all of your property lines, but you're going to probably put back some rights-of-way or some easements if there are existing utilities that have to be maintained.
If there were utilities that had to be maintained, and that comes in as part of the plat vacation process.
Yeah.
But it would, the interior lines would go away. It would strictly be one parcel
Yeah.
of conservation land.
Yeah, okay.
Okay.
Thank you. Go ahead, Drew.
Oh, sorry. Okay, so public hearing signs. These were posted on site down at the southern portion. We've got obviously both signs there for the proposed future land use change and the proposed rezoning. This is looking northeast into the area. This is at the corner of Seascape Street and Seascape Drive. This is looking east into the subject property. You do see there is some hardscape in there beyond the fence. That's looking west from the property at the south portion. These are the public hearing signs posted at the north side entrance. And that's looking that's looking south from the north side of the property at that entrance there where it's gated. Okay. All right, I'm going to go ahead and move on towards the findings for you. Once again, this small-scale amendment, 32 plus or minus acres, from mixed-use suburban to conservation. Subject properties are currently vacant, single-family, residential platted lots and greenways and rights-of-ways. They are adjacent to platted residential lots with single-family residents and vacant lots in the area. Okay, so general amendment conditions, need and benefit. A conversion to conservation would remove this property from future development while allowing passive recreational activities and implement goals and objectives as detailed in the comprehensive plan conservation element. Professional practices. The amendment proposes a replacement FLU that removes these parcels from development while protecting natural resources of Escambia County. The amendment conditions, for a small scale, the subject is 32 plus or minus acres, parcels. It's a use of 50 acres or fewer. It does not involve a text change to the comp plan, but only proposes a land use change to the future land use map. The properties are not within a designated area of critical state concern. As to the housing element, the proposed conservation FLU would remove these vacant parcels from the possibility of future development. FLU map designations is concerning urban sprawl, mixed use, compact development. Conservation FLU supports the protection and preservation of natural lands as conservation and appropriate use of these resources is critical to maintaining a high quality of life for county residents. Infrastructure. The request will not add any additional burden to the existing infrastructure and will remove lots from possible future development. Okay, as far as infrastructure concurrency, so to speak, potable water, sanitary sewer, solid waste disposal, potable water distribution, sanitary sewer collection and treatment, and solid waste collection and disposal are not required with this FLU change. Stormwater, transportation, and mobility. The proposed FLU change will not impact transportation and mobility. The existing rights-of-ways are currently gated and not in use. This condition will not change. Protected resources. This is dealing with the wellhead protection areas. The subject parcel is outside of any wellhead protection area based on the Escambia County's GIS system. Historically significant sites and any changes to those. This proposed small-scale FLU change does not propose development or disturbance that would impact any historically significant sites. wetlands and habitat, and urban forest. The National Wetlands Inventory Map shows a 1.25 plus or minus acres as wetlands, but the primary soils on the site, this is 30 and a half plus or minus acres, are hydric in nature. Changing the flue to conservation will not impact these conditions, and no changes to the forest are proposed. And that concludes the staff analysis.
Okay. So just to be clear, when we're going over to conservation, and you've stated that other than possibly some utility easements that may be out there, there would be no future development allowed on the property.
Correct.
The easements would only be if those utilities had to repair something or go through there for some reason.
Correct.
And that's typical in any easement, regardless of where it is. Okay.
So, a change to conservation future land use would further take this out of development, as the only zoning allowed under that would then be conservation zoning on top of the conservation
So
future land
put
use.
some pretty strong protections in place.
That is
This is
correct.
not going to turn into anything. It's
And
going to
that-
be left the way it is.
That is the county's goal.
Okay. Will the property be available for passive recreation, for paths and trails for biking or hiking or?
That is absolutely permissible in conservation future land use and zoning.
So the residents there could walk their dogs through there or ride bicycles or things like that, and that's acceptable?
This
Just-
change would just make it official
No-
that
no
the future
development.
land use.
Gotcha.
Correct.
Okay. I just want to get it on the record because we have a lot of folks here that are
Yes, sir.
concerned about the property, so. All right. Board members, any questions? Let me ask if we have anyone that specifically would like to speak on the map, on the map amendment, SSA 2021-02. I know some of you have put multiple items on your forms. Instead of going through all of them, let me just ask, does anyone want to speak on this issue at this time? Okay, sir, if you'll.
As opposed to speaking when you come back to the.
Yes, sir. I'm going to go through everybody who's signed up to make sure, plus or if they want to or not speak on that issue, but we'll give an opportunity in this hearing as well. Sir, if you'll state your name and address for the record.
David Lejean. I'm at 16761 Innerarity Point Road.
Okay.
So just to give you an update on the map and just to kind of put your mind at ease.
Let's go back to the map, please,
Yeah.
so we can.
So
look at it.
this map was drawn over 40 years ago. And it was based on, so I'm kind of like an investor. I've been buying property since I'm 20 years old. So 45 years of buying property. So when you map out a section like this, you map it two ways. So those roads are put in, they're either put in subsurface drainage or ditches, or you have the roads put in where the road's higher than the land. So these roads are higher than the land. So this map, you would not be able to use near these lots. It's virtually impossible. It's basically a watershed. All the lots around it are higher because of FEMA regulations. So what you have is basically a watershed here. It's flooded all the time. The roads they were probably put in 35, 40 years ago. They're not feasible.
Sir, are those roads asphalt, or are they clay-based, or you
They're
know what they're made
asphalt.
of?
They're asphalt, and they're way past.
They've been
reasonable use.
overtaken by vegetation and grown in and everything?
You couldn't use them. You couldn't use them. We have other roads that we have to repair already. But anyway, just to ease your mind, this is a watershed problem. If you were to develop this property, putting more dirt in this property would just shed the water in other places. We have a hard time draining the island as it is. So it's a really big drainage issue. So we have other issues on the island already where we're filling up lots, and then the water's gone because it has to go to the street now, okay? Red Seed is a perfect example. We fill up the lot, all the water goes into the street, and it's covered, So we have to do a lot of things drainage-wise as an HOA. To drain this would be virtually impossible without ditches, canals, maybe even a pumping station. And it would cost the county or us, you know, a fortune. So the recommendation, I know when you say conservation, we're taking it out of the market. Because we developed all the property around it, we've taken it out the marketplace. You know, so you'd be developing land that's underwater.
Okay, thank you. Yes, sir.
Staff, do we have a history on how the county acquired this property?
I don't have that background. That's why I said I'm quite certain some of these residents and members from the HOA would be able to give you more background on that. It's my understanding that it had to do with the water and sewer plan that was worked out. And I wasn't involved in that.
Is anyone here from the public that knows for sure? If you'll come forward, sir. State your name and address for the record. Okay, you just hand it to the staff there. Thank you, sir. Your name and address for the record, please.
Name is Steve Stroberger, 16787 Inner Point Road. So the way this was acquired was, yeah, you're right, when the water and sewer were dropped off at the county, later on, I guess the commissioners decided to figure out what else was attached to this. And there was a loan for some improvements on the water and sewer. And it's my understanding that the, let's see, that property in Seascape, and I think other properties that the Inner Island Development Corporation owned at the time, it was used as collateral for that loan. So it was all scooped up all at once at that point.
Okay. And the county, is your recollection that the county purchased it in foreclosure or something like that?
They paid off the balance of that loan in legal fees, and they got the water, sewer, and they got the land.
Okay.
So, you know, there's an MSBU right now on the residents out there. And so we're essentially paying off that loan ourselves at a 2.5% interest rate. So it's my contention that we actually own that property out there anyway. I kind of reject the idea that the county's making a decision on how to handle that.
Well, we'll say it's titled with the county right now, so.
Right.
All right. Sir, if you'll come forward. Thank you. Sir, have you previously filled out?
I signed up intending to
Okay.
speak on the zoning, and I would like to speak to that.
Okay, you
But
will. Yes, sir.
I'm happy to help. My name is Mike Floyd. I live at 16407 North Shore Court on Inner Island in Pensacola. And I've been heavily involved in this conservation effort and as well with the MSBU, which is closely connected to the ownership of this property, but is a separate issue that the Board of Commissioners will be dealing with. Just build on Mr. Legendre's and Mr. Stroberger's comments, the county, after a lot of dispute that happened before I moved here, came to own the Inner Island Development Corporation and the private sewer and water system that they operated, and as part of becoming receiver of all that property when the heirs to the original developer died, when the original developer died and the heirs to the heirs to the developer abandoned the water and sewer system, somebody had to take over that water and sewer system, and Escambia County agreed to be receiver of that system. And as everyone sorted through all of the stuff connected with the Inner Development Corporation, it turned out that there were these lots and some other lots and parcels that are that the county took as receiver for building, for figuring out what to do with the sewer system, but they also owned. And there was a lawsuit between the county and the heirs to Mr. Dennison, the owners of the people who came to own Interarity Development Corporation, to where the Dennison heirs claimed they should have this property, but it was separate from the water and sewer system. The settlement of that lawsuit, which was in 2013, I think, the settlement of that lawsuit resolved the title in favor of the county, but there was a payment of, I think, $500,000 to the heirs, which is also part of what we're told we're going to have to pay back ultimately. So I share Mr. Stroberger's belief that, no, we don't own this property, but we are fully paying for it as we've paid to build the new sewer system, because the county and ECUA have spent $5 million on the new sewer system, and that will be in our MSBU to pay off over the next 20 years. So we are grateful for the opportunity to say what we think ought to be done for this county, for this property. But we also feel very strongly that we ought to be able to decide that, because again, we're already paying for it. Is that helpful? I was glad to answer any other questions.
Sir,
Very helpful, thank you.
Real quick, sir, one more question.
Yes.
Does the ECUA provide sewer
to
the island?
There is one street, I think Seascape Street, in the far southeast portion of that area. I believe there is water there, but I don't think there's sewer anywhere in that area. I don't speak with absolute certainty, but that has been my assumption, because the intent was, throughout the process, there was no point in spending money to put water and sewer into this area if we just wanted it conserved anyway.
Sir, my question is the ECUA the sewer and water provider?
Oh, I'm sorry, yes. ECUA has now taken over the new sewer and water system that has been built over the last several years in the county. And I say partly facetiously that I'm delighted that we got through that construction process without any bloodshed or frivolous litigation. And the sewers and the water system are working wonderfully now, and I'm deeply relieved to be on ECUA as opposed to the old system, which there was much debate about, but I believe from the engineer's report that it was a disaster waiting to happen.
Thank you, sir.
Thank you.
Thank you. Sir, come forward, please.
Mr. Speaker?
Yes,
Mr.
Tim?
Speaker, I just had a question for either of the two residents, Mr. Strober or the gentleman that just spoke. I just want to be clear. This has been a point of contention, Interarity, and they have, his comment isn't lost, that he's grateful there was no bloodshed or anything after ECUA taking over. It is a great thing that that's occurred. I just wanted to ask the gentleman that lived there that it is their wish and desire for this to become utilized under FLU as a conservation area, number one. Number two, will that affect their current calculations on their MBSU, or were they using those lots in estimating the future MBSU assessments to the owners? That was one question. And the second is that understand that when the county vacates that property, they will have no responsibility whatsoever for those roadways. I don't think they're doing anything with them now. And I may be mistaken, they may be private.
They are.
Maybe clear that up for me.
Okay, I'll take your last point first. All the roads on the island are private. There's no county maintenance. The HOA is responsible for the maintenance, and I'm also treasurer of the HOA, and I've been deeply relieved this year that the cost of resurfacing a number of our roads outside the Seascape area has come in right a little under budget, so I'm breathing easier than I have been as we looked at that possibility. I'm sorry, refresh my recollection as to your other two questions, please.
It is the desire of the area, the homeowners
Thank you.
in general, to make this a conservation area. Is that correct?
It is absolutely the desire of the homeowners, and in my prepared remarks, I was going to say, this was considered at homeowners association meetings in both December 2017 and December 2020, and the vote was overwhelmingly in favor of conserving this area. I was just given this morning a number of written statements, and I found a few more of them that I haven't read in detail, but I'm assured that there's a stack of written statements from neighbors saying they enthusiastically support the idea of conserving this property because it's critical for stormwater management. It's also, we like the thought of having it available as recreation and green space, and we think we love our foxes and other wildlife on the island, and we want them to have a place to live.
Very
And was
good.
there
Thank you,
another question?
No, I think you answered. Thank you very much, and I could certainly see you guys making this into a beautiful green belt for an already. It's a great residential area. It's beautiful. I'm partial about this way, but anyway, thank you for answering that.
Thank you. We consider it a great privilege to live out there.
Go ahead, sir.
I just want, David Lejean again. I just wanted to let you guys know, as you asked a couple of questions about the sewer. Was there any sewer work done out there? There's no sewer work in any of those spaces. There is some water lines that were run, but they were run prior to this MSBU.
All right, thank you. Anyone else from the public that wishes to speak on this matter? All right, well, hereby close public comment for this hearing. Board members, questions, or someone ready to make a motion? This is on the map amendment.
I want to move this forward as written and as presented by the staff.
Motion, do we have a second?
Second.
Any further discussion? All those in favor say aye. Aye. Opposed? All right, everyone was in favor unanimously. So at this point, that concludes the public hearings for the regular planning board meeting. Before we go back into the quasi-judicial, I've been asked to have a few-minute break here. So I have 10:22, so we're going to come back into session at 10:30. Please do not address any of the planning board members or make comments about the upcoming case because we are going into quasi-judicial, and it would be ex parte communication. If you see us in the hall or something, please don't discuss it around us or say anything directly to us when we go, and we'll come back at 10:30. We are adjourned for temporary.
some more signatures.
The workshop today scheduled.
So they're just doing like their board meetings like this and just regular day-to-day work.
I don't know, I think. see, with the language as is, with the state, they didn't need no. Correct. No doubt. Correct.
They're gonna be stressed out because they're gonna get new documents.
Yes, and
GMR is already a beast. GMR is a beast for Thursday.
Crazy. We have one this year.
All right, folks, if I could ask you to please find your seats and come to order. All right, at this point, I would like to call the quasi-judicial planning board meeting for rezonings back to order. If you remember correctly, we did open the meeting before and read in some of our qualifying statements into the record. We did have our staff members sworn in. They still are under oath for this hearing. At this time, I'll ask our board members, has there been any ex parte communication between you, the applicant, agents, attorneys, witnesses, or fellow planning board members, or anyone from the general public prior to the hearing? Have you visited the subject property? And please also disclose if you're a relative or business associate of the applicant or agents. And we'll start, Tim, if you're on there, if you would go ahead and answer those questions for us, please.
No to all, very familiar with the area.
All right, thank you, sir. Good morning, Steve.
No to all.
All right, thank you.
No to all.
Chairman, no to all.
No to all.
No to all.
No to all.
All right, and just to let the record reflect, Mr. Walker did have a previous engagement he had to go to. We still do have, what do we have, 5 members here present, so we still do have our quorum with Tim on the line, so we have 6 members total. Obviously, this is the county, so I don't think they'll have any opposition to presenting maps or photography to start the meeting off, but if you'd like to go forward, who's going to be presenting? Okay.
Morning.
Good morning.
Allison Lindsay, Urban Planner Development Services. So this is the Z 2021-06. This is a location map showing the area outlined in red. And this is the zoning map showing the LDR with also a small portion of HDMU to the far west. And this is the existing land use map. This is the current future land use map. And the proposed future land use of conservation. This is the aerial photography showing the area outlined. These are the rezoning signs, the public hearing signs that we posted on the south side of the entrance. This is looking northeast onto the corner of Seascape and Street and Seascape Drive. Looking east onto the subject property. Looking west from the subject property. This is the public hearing signs that were placed at the north side of the entrance. This is the north side entrance. And that's the end of the photos and maps.
Okay, and as we start the case, I think it's important to recognize that, of course, this rezoning is contingent upon the hearings that we just had being moved forward through the Board of County Commissioners and through Department of Economic Opportunity. So it's contingent upon those. So, okay, at this point, go ahead.
Okay, so yes, this is, the future land use currently is MUS. If it gets approved, the small scale gets approved, then it will be conservation. This is from low-density residential and the small HDMU to conservation. So criteria 1, consistency with the comprehensive plan, that the amendment to conservation is consistent with the intent and purposes of the future land use, and the conservation FLU is intended to protect wetlands, marshes, and other natural resources. Consistency with the zoning, the, sorry. Got to find my right page. There you go. Oh. Thank you. Okay, so the proposed amendment is consistent with the intent of the Land Development Code, and the conservation zoning, it can be established in any of the, within all future land use categories. The intent of this district is so that you can preserve the watersheds, the wetlands, the wildlife, the coastal dunes, and any other environmental sensitive lands. But it will also allow for passive recreation opportunities, as well as to conserving the area of future land use. So the compatible criteria C, compatible with surrounding uses. All the permitted uses of the proposed zoning, it's not anticipated that the rezoning, it will be compatible as defined in Chapter 6 with the surrounding uses. The uses are all surrounding undeveloped lands, and they should be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of the residential use, there's no additional burden to demonstrate the compatibility of specific residents or activities, activities protected by the Fair Housing Act. So the findings for the compatible uses is that it is compatible with the surrounding area. There were zones that were LDR, HDMU, and LDMU. The surrounding uses are residential and passive recreation. The proposed rezoning will preserve the environmentally sensitive lands and would not change the compatibility of the surrounding areas. Criteria D, appropriate if spot zoning. This is considered spot zoning only in the definition. It will not affect any of the surrounding residential neighbors. So the conservation zoning, it will preserve the wildlife habitat, the wetlands, and other environmental sensitive lands, while allowing the neighbors to also enjoy the passive recreation activities. And it's compatible with all the surrounding uses. The conservation zoning will preserve the wildlife habitat, and the requested zoning to conservation would be considered spot zoning, but it's only in the designation. It's the only designation that's allowed in the FLU. And the change backside. Appropriate with change or change conditions. The land uses or development conditions within the area surrounding the property of the rezoning would not change in any way that would impact the compatibility involving this site. The area remains undeveloped in order to protect the wildlife and the preservation of the land, which does have its limitations for development. That's the end of staff's findings.
Okay, thank you, Allison. Board members, any questions for Allison at this point? Okay. And since the county is acting as the owner in this case, we don't really have anyone to cross-examine, so the members of the public will be the one that'll bring forth any questions or concerns. For those members of the public who wish to speak on this matter, please note that the planning board bases its decision on the approval conditions exceptions described in section 2-7.2 of the Escambia County Land Development Code. During our deliberations, the planning board does not consider general statements of supportive opposition Accordingly, please limit your testimony to the approval conditions and exceptions described in 2-7.2. And this is the important part about this meeting we're in now. Those individuals who are present and give testimony will be allowed to speak at the subsequent Board of County Commission hearing. If you don't speak at this hearing now under quasi-judicial, you cannot speak on this particular case at the Board of County Commissioner. Now, you could speak on the other ones that we had, but on this particular case, all testimony has to be on the record today. So I know there was several folks that said they had statements from others who weren't here. There's no point in reading those into the record, because if they're not here, we can't use their statements, okay? They have to be present and give testimony under oath for it to count. So I understand there might be others that support it, but if they're not here, unfortunately, that won't count. So we're going to go through, I'm going to go through all of these because I was confused as to some where people would want to speak. We'll give you the opportunity. If you don't want to speak, that's fine. Mr. Mike Floyd. And sir, in this case, you'll first be sworn in by our court reporter, and then state your name and address for the record.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. Your name and address, please.
My name is Mike Floyd. I live at 16407 North Shore Court on Innerarity Island in Pensacola, 32507. I'm speaking today as an individual citizen and property owner on the island, though for what it's worth, I am the treasurer of our homeowners association, and I've been very deeply involved over the last couple of years with the issues related to the sewer project and the issues related to our desire to have this property in conservation, which we see, those are two distinct sets of issues, but we see them as closely connected. I've spent a lot of time explaining these things to other residents because there's been a great deal of misunderstanding about what has been going on. As you probably know, the question of conserving this property was addressed at both our December 2017 and December 2020 Homeowners Association meetings, and at both of those meetings, the vote was overwhelmingly in favor of putting this property in conservation. I've also was given this morning a stack of written statements that my colleagues have collected from other neighbors, and we've asked that they be put into evidence for this matter if that's possible. There's very little dispute about our desire to have this property in conservation. You probably also know, again, it's closely connected to our new sewer and water system. We got through that. It's working fine. Nobody was seriously harmed, though there were some heated conversations from time to time. And I take a great deal of comfort personally in knowing that ECUA is now responsible for our sewer and water system instead of the old private system that I had much less confidence in. And I do fear that a few of our neighbors are still kind of grumpy about what that process is going to cost us, and I understand that, but unfortunately nobody has stepped up to offer to pay for our sewers, so we're going to have to do that. I am very hopeful that the county's cooperation in putting this land in conservation will go a long way to easing the irritation that some of our folks have felt about the process, and I'm very grateful to the county staff and the county commissioners for their support and responsiveness on this set of issues. Again, we very much like the idea of having this property in conservation for recreation and wildlife habitat, because we love the foxes and raccoons and deer and other things that wander around the island from time to time. But the critical issue really is stormwater management, in my view, because Hurricane Sally showed us that our whole island, may I have 30 seconds?
Yes, sir, go ahead and finish up.
Hurricane Sally showed us that our streets will flood. And I live in the very middle of the island on relatively high ground, but there was a foot of water, maybe 2 feet of water in our street for at least a full day after Hurricane Sally. And we had a number of other neighbors whose houses were flooded, as well as just the street and the yard. And this is only going to get worse because people are building out the existing lots that are available for development, and every time you build on one of those, it pushes water off to someone else, and we're seeing that on our street. But having this this area, as Mr. Legendre described it, a watershed, is really important to soaking up this water when it comes and keeping it from going to a place where it will cause more damage. So we're, again, grateful to the county, the planning board, and the staff for your hearing us on this and for your support of this idea. There, other stuff we need to do, certainly, because I have said many times that I want this protected not only by belt and suspenders, but also a rope tied around our waists. And so we will work with the county on an ongoing basis to get to those other things. But this rezoning is a wonderful step forward in what we've been looking for hoping would happen for quite some time, and we're thankful. I'd be happy to respond to any questions anyone has.
All righty, sir. Before we go further, you had mentioned part of a legal process, which is bringing something into evidence for the case.
Yes.
Some documents that you have. We're going to ask our county attorney the opinion, but did you say that those were statements from individuals in the neighborhood?
I can show you an example. They are forms that we had neighbors who went door to door.
If you'll give it to the attorney. And are those statements notarized or acknowledged in any way?
No,
okay.
they are not.
Kia, my question is, obviously he's offering it to be entered into evidence and the board could make a motion to accept that, but in your opinion, do they have legal standing in this type of proceeding?
So they're essentially petitions, and petitions are not competent substantial evidence. You guys can take them, but you cannot use them in your decision-making process as competent substantial evidence.
Okay. And the basis for that basically is because they're not here to attest to that, and they're not notarized and all those kind of things? Is
Right,
that
and
correct?
no one is here for cross-examination. We can't ask them any questions.
Okay. So board members, you've heard the opinion of the attorney. As a courtesy, we can bring it in as evidence, but it can't be relied upon because of the reasons the attorney stated. So pleasure of the board on accepting those into the record.
I'd make a move to present, to have those as on hand as evidence. I would just like the board members to understand and maybe get some inkling of the residents' desire.
Okay. Motion and a second. Do we have a second?
I'll second.
Okay, second. Do we know exactly how many there are? Will they be listed? Should we list them as all as one exhibit, Kia, to make it simpler?
Yes, it could be one composite exhibit. I believe Ms. Crawford may have a general idea of how many there are.
Yeah, they made copies, but I just got them this morning and I haven't counted.
Looks like a pretty good.
It's a pretty good stack.
Maybe
Yeah.
40 or 50?
Easily, yeah.
Okay. All right, so what we'll do is, as you heard the legal opinion, they're not really a legal basis that we can use, but it's information that we can pass on to show that there's some, concern out there.
Thank you.
We'll list them as Floyd Composite Exhibit 1, because Mr. Floyd entered them into evidence. And we do have a second, so all those in favor say aye. Aye.
Aye.
Opposed? All right, so they'll be entered into evidence as much strength as they can bring to the project. Okay, so thank you for your comments, sir. We appreciate it.
Thank you.
All right, our next speaker, Ms. Meredith Crawford. Did you want to speak on this one? Okay, decides not to speak. Cheryl Lively?
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning. If you'll state your name and address for the record, please.
Cheryl Lively, 5677 Inner Circle, Pensacola.
Thank you. Go ahead.
As a resident of the island for the past 35 years, we've seen a lot of development during that time. I think when we first built, there were 10 houses on the island. There are now close to moving towards 200. We're not anti-development in our community, but we are certainly cognizant of the gift that we've been given in the environment that we live in. And I think that this proposed conservation district recognizes that and addresses problems such as stormwater management and limited infrastructure development to support further building in that specific sensitive area. And we are very appreciative of the county's and staff's recommendation to establish it as a conservation district.
Okay.
That's it.
Thank you very much. David Bruni. Good morning, sir. Be sworn in and state your name and address for the record.
Right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. My name is David Bruni. I'm a homeowner at 16500 Inner Point Road, Pensacola, 32507.
Thank you, sir. Go ahead.
My lot is directly adjacent to the land that would be designated as this conservation area. I could not possibly be a stronger advocate for the designation of this as a conservation area for wetlands management, for wildlife habitat and whatnot. Thank you.
Thank you, sir. I'm sorry? In quasi judicial, they have to put their comments on the record. What he was asking was, it seems like a lot of you are in support of it, and you'll probably be saying similar things, but in quasi judicial, because the record is exact, we have to hear your comments to go on to the commissioners. David, if you'd like to come forward again, sir, and be sworn in, and please state your name and address.
Do you solemnly swear the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
My name's David Lejean. I'm at 16761 Inner Point Road. That's Pensacola, 32507. I just wanted to put on the record, the property looks like it's a lot of lots and there's a lot of volume and there's an opportunity to sell a lot of lots and it would come to the county. The reality is, if you were taking that plot of land today and trying to go to a zoning commission, you'd probably get 20 out of those 90 lots. Because you'd have to have watershed, you'd have to put in sewage, you'd have to put in some kind of drainage. And the drainage, for the way we've built the island, we've built everything around it. So the drainage would have to be started there and go through other people's properties. And it wouldn't be these little ditches that we have, it would have to be canals, it would have to be maybe even a pumping station. So as it stands now, it's almost like a watershed area. So as we fill it up with 10 to 20 loads, each lot takes 10 to 20 loads of sand and concrete. As you fill up that area, you eliminate all the trees, the water will flow somewhere. And it cannot flow out the island fast enough. So if you take a look at a funnel, okay? So the watershed is the top of the funnel. And then, of course, everything on the bottom side, trees, they take the water. The land takes the water, okay? The little ditches take the water. If you make the land higher, okay, it puts the water in the top part of the funnel and it takes the bottom part of the funnel out. So if you look at the funnel as the bottom part is the denominator and the top part as the numerator, you're putting more and more in the numerator and getting less and less out of the denominator. So what happens is when the water comes down, and as you know, it comes down in buckets in Pensacola. There's just no place to get it off. We're above sea level, but it doesn't mean anything. So those waters go into the streets, it goes into your yard, and then it goes into your house. And we've already experienced that with the lots we have. And we're really struggling to stay on top of that. Thanks.
All right, thank you, sir.
Legendre.
Steve Stroberger? Steve Stroberger, see, he left, okay. Dennis Geary? Good morning, sir, please be sworn in and state your name and address for the record.
Absolutely.
My
Raise your
name,
right hand, do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Spell your last name.
Geary. My name is Dennis Geary. I live at 5612 North Shore Way with the rest of my fellow residents back here. Unfortunately, because I'm coming up after some of my residents and fellow neighbors have done an amazingly good job of walking through some of the issues. But I did want to come up and acknowledge the fact that the neighbors, our neighborhood as a whole is very passionate. I think you can see that. And we lost some people, I think, due to some confusion on timing here. But everyone's very passionate, and I think a lot of people are passionate for multiple reasons, which is great. You know, first and foremost is we love the wildlife, the ecosystem. Like Mr. Floyd spoke about the foxes. It's a lot of reasons why people move there. But the fact of it is we've also seen, since I've been there, since I moved there about 4.5 years ago, we've seen about 60 new homes being built. Certainly, those are lots that people can sell. They're privately owned. We're going to see probably up to another 100 homes built, I think, in the next 5 years there. So that, again, is one of the reasons we're really concerned about this seascape area, because, again, what we've seen from Sally, I personally seen in Sally was we had about 2 to 3 feet of water in this area on those road systems back there. I live on one of the higher points of the island, and the rain and the flooding on our street put water within half an inch from coming into our back door. So where does that water go if it's built up on? It's going to go into all the inland homes, many of which didn't flood. If we had another Sally or another large tropical storm or something like that, and that's developed, the entire island would be flooded. So that you can imagine the amount of damage and liability to that. So that's my primary concern. Certainly, I love the wildlife and the ecosystem. It's just a beautiful place to walk through and enjoy. But the rain and wind mitigation, the ability that affords us we'll never be able to replace it if it is lost and built upon. And unfortunately, unlike a new development where you plan ahead, our original development is quite old. It really wasn't planned out the same as you would a new development today, putting in rain mitigation and rain waste water ponds and things like that. We just don't have that in the system. And certainly if it would be developed, I would imagine it would be a one developer buying it, very likely through an auction type system. We would not be afforded that. They would just build on it, period. So,
All right.
Appreciate it.
Thank you, sir. Appreciate it. All right, that's everyone that I have signed up to speak. Is there anyone who has not already spoken that wishes to speak on this matter? Remember, if you're going to want to speak at the commission, you have to speak here today first. So, okay, yes, ma'am. If you'll come forward, please. And be sworn in and state your name and address for the record. And before you leave today, if you'll complete one of the forms for us. Thank you.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing?
I do. My name's Nancy Ellis. I live at 5846 Red Cedar Street. I'm new to the area, just 5 months. Post Sally, so I can't speak to Sally, but just regular rains on Red Cedar and the fact that the island isn't draining currently, I can attest to that. I can't, just a normal rain, walking out my front door, I cannot walk up in the street. It'll be flooded, garbage cans are floating. There's construction across the street, and there's a porta porta potty. And I worried that that thing was going to get tumped over. That's how high the water gets on the road. I've had UPS drivers turn around, mail deliveries not made because of the flooding. So I can only imagine what Sally did. So the construction across the street has pushed more water into the road. And although where the conservation area is not next to my house, it is on the island. And so I'm very much in favor of the conservation area.
Okay. Thank you for your comments. All right, anyone else that hasn't already spoken that wishes to speak? Okay. All right, we are hereby going to close public comment portion for the quasi-judicial hearing. Board members, any questions of staff or any of the public speakers? Staff, anything else to add? All right, Chair will entertain a motion on Z 2021-06.
Move to approve.
Okay. Motion, do we have a second?
Second.
A second. Did you pick up? Okay. Just wanted to make sure you picked up who made the motion and who second. Any further discussion? All those in favor say aye.
Aye.
Opposed? All right. It looks like it was unanimous with everyone voting in favor to approve. So good luck with it, folks out there. It looks like it'll be recommended to the commissioners, and certainly recommend that this board does not have purview over drainage issues and things like that that you may be experiencing out there, but obviously the commissioners do. So recommend that you continue to work on those issues and make your comments known at the Board of County Commission meeting. So, all right, with that, that is our only case for today on quasi-judicial. Is there any other business for our rezoning hearing? All right, the next rezoning hearing will be Tuesday. Well, it's not on here when it will be.
It's on the regular meeting, September 7th.
September 7th, okay. I think there's a typo, it didn't get filled in here. It says Tuesday month day, so we just want to make sure that we announce it correctly. September 7th, and it's not 2016, it'll be 2021.
That's okay, that's okay.
That's all right. Must have used an old agenda. Okay, so we're hereby close out the quasi-judicial hearing, so. All right, back to regular planning board. I'm going to reopen regular planning board meeting just to go through our remaining agenda items. And Rachel, this may just be part of your responsibility. I noticed that the rezoning hearings kind of looks like it's on a regular planning board agenda with all the items down here, and then the other ones flip-flopped. So we typically see the rezoning one say quasi-judicial or rezoning, and then not have the other items. So just watch that one in the future. Okay, any action items or discussion info items presented?
Yes, sir. And Rachel going to help me out with this. As you know, just briefly, just to provide where we are with an update. I believe at the next planning board meeting, which will be in September, I believe September the 7th, if that's correct.
Yes.
We are planning on, and help me out, Rachel, we're planning on having an OLF8 public hearing. Okay. At that hearing, at that particular planning board meeting, it may be rather lengthy, and we do need every planning board member to attend. If not, please let us know as quickly as you possibly can. We are basically coming to the end of the contract for DPZ as it is related to the old LF8 master plan process. At the next planning board meeting, September the 7th, which is my birthday. Yes.
Cake and ice cream.
No, well, if you had cookies, I think.
Duly noted.
Yes. It's going to be a rather long meeting. We will be having a public hearing on the implementation plan. That is like the rules and the regulations for the master plan of Paducah, almost like the land development code. So that is gonna be the public hearing on that day. It may be rather lengthy because what other items do we have scheduled?
We have a rezoning that day and then just the OLF8.
Yes, I want to consolidate the meeting to give you opportunity. Now, the rezoning, that's quasi judicial, nothing else is scheduled that day. So it may run into, until after 12 o'clock, it all depends. So, but that's going to be a very important meeting, and we're going to try to provide, let's try to provide lunch. Let's try to provide lunch for them.
We have the meeting room for, we don't have to leave at 1 or 1:30 or something?
We can get it. I'll talk to code enforcement.
Yeah.
Okay.
Because we got to, because see, it is my understanding that, I believe that their contract will be ending sometime expiring in September, so we got to try to move ahead with that. So
Okay.
that's gonna be that on that date.
Now, what makes you think that it will be so lengthy? Is it the information,
It's
or
the-
you expect a lot of input from the public?
It could be both. It's gonna be some new regulations, new plans. It's a new, different concept, form-based language. You may have some questions on implementation, how to apply, but it's completely different because of new urbanism and the concepts that's associated with this master planning process. So once you see the once you see it, we'll send you all the packet, and you may have some questions on some highs and the whys, and that's the opportunity. It's gonna be a public hearing. So we need to move forward with that. Also
Okay,
yes, sir.
Now that you've said that,
Mm-hmm.
I can foresee that there will be a lot of public comment
Mm-hmm.
because it's not the way we normally do things.
Yes,
So
sir.
what can we do to mitigate so that we don't have, I mean, we obviously want public input, but we don't want redundancy in hearing the same thing over and over. So is there anything that can be done to issue to both planning board members and the public that says, this is an accepted way of doing it, it's done in other parts of the country?
Yes, sir,
Here's some, what might be a little different from our code, but here's why we think it's better. I mean, just something to
Yes, sir.
kind of mitigate some of that?
Yes, sir. We'll have Mr. John Fisher, we'll work with DPZ to make sure that is laid out at the beginning on that, and we'll try to mitigate, reduce, try to make it as easy as possible for the public to understand what we're doing. But we'll get with John Fisher and the project manager and DPZ to try to make sure that they're there to try to address make it easier. Because it's going to be, the language is going to be completely different as some of the performance standards. But it got to come before y'all because you are the planning
Okay.
committee. Yes, sir.
Well, and I probably speak for everybody here, but since it is going to be so different, what's the earliest that we can start looking at it and reviewing it?
If I can add something, on the June 1st regular planning board, the actual design code is already attached because that was actually an action item on that meeting. When DPZ did their presentation,
Right.
we actually did that part first. So I don't know how much has changed since then, but you can actually look at that on the website right now from June 1st.
Right.
And-
And we can send you, and thank you, Rich, that's a very good point. And we will send you the final draft, so you can start comparing and looking, you can start looking at it right now to, it has changed, but I don't think substantially.
Right, okay.
Mr. Speaker?
Yes, sir.
And Mr. Jones,
Yes,
do
sir.
we or do we not have somewhat of a template in the Perdido overlay and how we did the implementation with DPZ and keeping them on, if I'm not mistaken, for a portion of that implementation, or am I incorrect?
That question is being raised right now, and I don't have an answer for that. I don't have an answer to that question, Mr. Powell, but that question is being raised right now. But I do not have a definite answer.
Okay.
Okay, so please, planning board members, if you can, let us know if you can't be here. We definitely need a quorum. We got to have a quorum. This is not a discussion item. It's going to be for a public hearing. The next urgent matter is that As you know, on the, I think, I forgot the planning board meeting, the BCC made a motion, I think at the last, one of the last BCC meetings, basically to direct staff to review, to begin, to bring back to the planning board for the removal of the sector plan. For the removal of the sector plan. And they want us to basically, to bring it back to you all with language and all of that. We're in the process, we're going to need to have a workshop. We're requested to have a workshop only on that item in September. In September, a workshop, right? A workshop on that item.
My suggestion is kind of what we did previously, where you guys had your planning board meeting on a Tuesday. Next week was a break off, and then we came back and had a workshop that next Tuesday. I feel like Tuesday's easy to remember. You'll have a break the week before and the week after before your next meeting. So that would be September the 21st.
So the staff and along with Drew and myself and legal, we have been working on some things, trying to get the total number of parcels. It's not a hard item to do, but we have to make sure that we do it correctly to be able to withstand any type of challenges, because once we remove the sector plan, it got to be removed entirely. We cannot keep certain entitlements and certain other things. We got to remove it entirely. And as you know, many of the underlying zoning, the underlying future land use category, many of them was AG. So therefore, once you remove it, it has to revert back to that. But we, in the process of trying to think about how we want to make those people whole, because they invested large sums of money because of the sector plan and those parcels of land. So Kia Johnson, the legal department, and Drew and myself, and along with John and some other plans, we're going to be relying upon them to direct it, because we don't want no unnecessary lawsuits or takings. Like I said, takings is just not that easy, y'all. It's not. So we're trying to protect that. But that is coming. That is the direction of the board, and that is what we are proceeding in to bring back, to begin that discussions. We're looking at the parcels of land right now. How many parcels basically has the potential we'll have to make consistent with the current flu, because you can have a current zoning, and once you remove the underlying layer of the sector plan, it's not consistent. LDR and AG is not consistent. So we got to make those people whole and make consistent. So it's not convoluted, but it's complex. We have a set order, so that's why. But we definitely need to begin to have this discussion in September with the planning board. It may be short. Y'all may so go for it, remove it, get rid of it, direct staff to keep on proceeding. But we definitely want to have that discussion with y'all, separate from the regular planning board meeting, so that we can discuss that. Because we knew that once we have a public hearing on it, you're going to have the yays and the nays and the big, large landowners being here, and they're going to want to make sure. So we're trying to do our due diligence up front. So when we do comment for it, for the actual public hearing with you all, we can keep going forward. So that's why we're having the discussion. We want to have the discussion first.
So at that meeting, how long, I mean, we thinking it probably be done before lunchtime?
It may. It may. I'm thinking it may. I really, because they're going to be having input in what they're thinking about the language and the making whole, and we're going to be presenting, Drew and myself, along with our address department, we're going to be presenting you the total number of parcels. People say I always bring Drew, because Drew is the technical brain of the bunch. He's the Steve Urkel of the bunch.
Well, let me just make sure that I understand. I mean, the commissioners have said this will be removed, so it's not an issue of whether or not it's going to be removed.
Yes,
it's an issue of how we go through the process.
Yes, the process.
What I can foresee is there will be some people that come forward that are protesting removing it.
Definitely.
Right, because they want to keep it in place. But is that really what our task is, to decide whether it should be removed or not, or is our task just to go through the technical aspects of it?
I believe that your task is to go through the technical aspect of it, to hear it, because it got to come before you, and you can consider, and everybody may not, some of the plan, they may want to keep it. But our responsibility is to bring back the motion And I believe that your responsibility is to do the technical aspect of it and hear it out thoroughly and sufficiently, and to make sure that if it is removed, that there's language to protect the property owners who may have had some vested interest in developing because of the sector plan, and make sure they are made whole.
So, Mr. Chairman, I can read the exact motion from the Board of County Commissioners. So the motion was to ask the planning board to consider the removing of the overlay district while maintaining those underlying increased areas of entitlements and densities in those 3 areas through some method, whether it be a savings clause or something like that.
So they did in fact say.
Yeah, it's
for
still a
the
question
planning
as to
board
whether
to
we do it.
consider whether we want to remove it or not.
Yes.
I mean, the underlying atmosphere is that they want it removed, but they still want us to consider whether it should be removed or not.
Which means it's a dual-purpose hearing, and we will need to listen to any opposition
Yes,
to
definitely.
removing it at all.
Oh, yes, definitely.
Right, that's what I was getting to is, you know,
Yes.
it's a big difference.
Yeah.
Yes.
If it were just the other, wouldn't we have the latitude to, at the very least, disregard oppositional statements?
Yeah.
But this says it's not a done deal, and we
Yeah,
gotta hear it.
and it would be helpful for you guys to go back and watch that Board of County Commissioners meeting. It was the July 8th meeting, and it's at the very end of the meeting on the county attorney's report. So if you go back and watch that discussion that the board did have to understand how they got to their motion, that would be great.
Yes. And I think that could help give you the exact intent. Sometimes what is written is not always the intent, is what is verbalized, and I think you can understand what I'm
And
saying, yes.
speak to your commissioner or commissioners. We're allowed to speak to them directly concerning this without violating any sunshine laws or anything?
Yes,
Okay.
since you're on different public boards, as long as it's not 2 of you going to speak to one commissioner or 2 commissioners speaking to you.
So you guys can pick up the phone, find out what the commissioners want, what your commissioner wants, and go from there, so.
It's a lose-lose situation either way.
Okay.
It's not gonna be fun,
Yeah, it's not gonna be fun.
not at all.
It's not gonna be fun, but again, the staff marching orders is very, very clear. We do understand our directive clearly. So you have to hear and do what just the planning board sits as.
Yeah. I remember when the sector plan was being considered, something that I thought was very helpful at the time, and I can't remember exactly how this was done. It may have even been the old overhead projectors, but I think they had a current map and then had zoning, maybe had future land use on it. And as the presenter was kind of adding the slides, you could kind of see them going over top of each other and what it changed, or so to speak, because like you're saying, we're peeling off one of those slides, one of those layers. So I don't know if that would be helpful in making the public understand that there's 3 or 4 layers here. We're taking this layer off, and here's what we're left with, and here's the concerns that we have. I don't know.
Yes, sir.
It just-
And we are, and Mr. Briscoe, you've been doing this a long time. You're thinking like staff, and we are planning on having some maps. Our GIS department, we will have the current sector plan. Once it removed, what it would be, the zoning, we're going to have all of that spreadsheets, the number of parcels. We're going to have all of that as a workshop. And so you'll be able to have all the information and ahead of time.
So the workshop will be discussing the comprehensive plan as well as the flu maps and
Yes, sir.
any LDC changes that might be necessary
Yes,
and all
sir.
that.
Yes, sir.
So that's not gonna be a short meeting.
The LDC is not going to be that much.
Not, yeah, that'd be minimal, but
Very minimal.
The DSAP is the flu
Right.
for those parcels. Sorry. The DSAP is the flu for those parcels. So there's already incompatibility in there.
Yes.
And we certainly wouldn't be looking at in a situation where someone would be losing any rights that the county may have granted through that.
That goes back before all the changes were made. So you're gonna have to then go back to those originals and bring them forward.
Yes, sir.
Okay.
Yeah.
That-
Speaking of layers, yeah.
Yeah.
Oh, yeah.
You guys understand what we're talking about? That DSAP was put in place before all the categories were changed and everything, so, okay.
It's
Well,
gonna drag new problems with it when you
yeah,
pull it out.
it will change them, so,
Opportunities.
wow.
And then we're
trying.
canceling October,
County
right?
commissioners, your planning staff needs a raise. There you go. You guys can thank me after the meeting.
Y'all just get taller chairs is what he means.
Yeah, so we thank y'all, and I think each one of y'all have bring valuable input in policies and decisions and ideas, so we're gonna get through it because we have to. And I think it still be for the betterment of Escambia County. That's the overall intent.
Okay, thank you. We don't have any members of the public here, so there's no public forum. Anything else to add, Horace, Drew? Anything you guys want to add? Okay. Kia, anything from county attorney's report?
Nope, nothing from me.
Okay, we've already talked about scheduling of future meetings. I would ask, Rachel, that you get those dates out immediately so everybody can get them on their calendars and remember, because we do need everybody here. We need everybody's input, so. All right. Is there anything else for the meeting today?
So, thank you.
All right, that's it. Then we are adjourned. Thank you.
Thank you for entertaining me offline.
First member to wear a ball cap through the whole meeting.
I know. Well, I took it off during the pledge. I'll tell you.